Waheguru Ji Ka Khalsa, Waheguru Ji Ki Fateh. Welcome to SIKH Channel live legal program. ਇਹ program SIKH Channel ਪੇਸ਼ ਕਰਦਾ ਹੈ ਤੁਹਾਡੇ ਵਾਸਤੇ ਕੋਈ ਵੀ ਤੁਹਾਨੂੰ ਕਾਨੂੰਨੀ ਤੌਰ legal issue problem ਹੋਵੇ, ਖਾਸ ਕਰ ਇੰਗਲੈਂਡ ਅਤੇ ਵੇਲਜ਼ ਤੇ ਕਾਨੂੰਨਾਂ ਤੌਰ ਸਕਾਟਲੈਂਡ ਦੀ ਆਪਣੀ legal system ਹੈਗੀ, ਪਰ ਕੋਈ ਵੀ ਇੰਗਲੈਂਡ ਅਤੇ ਵੇਲਜ਼ ਤੁਹਾਨੂੰ ਲੀਗਲ ਕੁਐਸਚਨ ਹੈ ਕਿ ਸਵਾਲ ਹੈਗਾ, ਕੋਈ ਵੀ ਪ੍ਰੋਬਲਮ ਹੋਵੇ, ਅਸੀਂ ਕੋਸ਼ਿਸ਼ ਕਰਦੇ ਸਿੱਖ ਚੈਨਲ ਤੋਂ ਸਭ ਤੋਂ ਵਧੀਆ ਵਕੀਲ ਇੱਥੇ ਦੇ ਤੁਹਾਨੂੰ ਪੇਸ਼ ਕਰਦੇ ਐਂਡ ਤੁਹਾਡੀ ਮਦਦ ਵਾਸਤੇ ਤੁਹਾਡਾ ਕੋਈ ਸਵਾਲ ਹੋਵੇ ਉਹਦਾ ਸਵਾਲ ਜਵਾਬ ਦੇਣ ਦੀ। ਅੱਜ ਦਾਸ ਦੇ ਨਾਲ ਹੈਗਾ ਬਹੁਤ ਸੀਨੀਅਰ ਸੋਲਿਸਿਟਰ ਐਂਡਰੂ ਲੂਕਸ। ਐਂਡਰੂ ਲੂਕਸ ਇਹ ਹੈਗਾ ਵਕੀਲ ਕਾਰਡਿਫ ਦੇ ਵਿੱਚ ਵੇਲਜ਼, ਪਰ ਇੰਗਲੈਂਡ ਤੇ ਵੇਲਜ਼ ਸਾਰੇ ਜਗ੍ਹਾ ਦੇ ਕਲਾਇੰਟ ਹੈਗੇ ਐਂਡ ਅਸੀਂ ਐਂਡਰੂ ਨਾਲ ਅੱਜ ਗੱਲਬਾਤ ਕਰਾਂਗੇ, ਉਹਦੇ ਬਾਰੇ ਪੁੱਛਾਂਗੇ ਕਿਸ ਤਰ੍ਹਾਂ ਕੰਮ ਕਰਦਾ, ਕਿਸ ਤਰ੍ਹਾਂ ਮਦਦ ਕਰਦਾ ਕਲਾਇੰਟਾਂ ਦੀ, ਕਿੱਦਾਂ ਨਹੀਂ ਕੇਸ ਲੈਂਦਾ। ਐਂਡਰੂ ਦਾ ਐਕਸਪੀਰੀਅੰਸ ਕਾਫੀ ਵਧੀਆ ਐਕਸਪੀਰੀਅੰਸ ਹੈਗਾ, 30-40 ਸਾਲ ਹੋ ਗਏ ਵਕੀਲ ਦੇ ਕੰਮ ਕਰਦੇ ਨੂੰ ਐਂਡ ਇਜ਼ ਅ ਵੈਰੀ ਸੀਨੀਅਰ ਐਕਸਪੀਰੀਅੰਸ ਸੋਲਿਸਿਟਰ। So without any further delay, let's meet Andrew Lucas. Andrew, welcome to the SIKH channel.
Thank you, Davinder, and thank you for inviting me onto the SIKH channel, and good evening to all your viewers.
I was just trying to give an introduction in Punjabi to your services and experience, and I described you as a senior solicitor with over 30 years experience of a wide range of matters. I think your area of specialism is commercial litigation, insolvency, and particularly contentious probate. Is that right?
It is, and thank you for your very kind introduction. Yes, I do specialise in those areas.
But perhaps we can start with contentious probate, because I think most people understand probate. Probate ਹੁੰਦਾ ਜਦੋਂ ਕਿਸੇ ਦੀ ਚੜਾਈ ਕਰ ਜਾਂਦੇ, ਉਹਨਾਂ ਦੇ ਫਿਰ ਜਿਹੜੇ ਜਾਇਦਾਦ ਹੁੰਦੀ ਆ ਉਹਦਾ ਸੰਭਾਲਣਾ ਕਿਸ ਤਰ੍ਹਾਂ। Probate is a process after death in dealing with an estate. Is that right? And contentious probate, what is that?
Well, contentious probate is typically when a will is disputed. You're quite right, probate is a process after death, and what generally happens is that when someone sadly passes away, there are really two scenarios, both probate, but the first is when they've made a will, and the second is when they haven't made a will, what is known as the deceased being intestate. If the deceased has made a will, that situation is governed by law, by a piece of secondary legislation called the intestacy rules, and that sets out who receives the estate upon death. Typically, it's going to be half of the estate to the wife, a life interest to remain in the home, and the remaining half to the children. That's prescribed by law, and then one applies for a grant of what's known as letters of administration, which is similar to a grant of probate, which is a grant you obtain when you die without making a will. The importance of having a grant of administration is that it enables the beneficiaries of the estate to access the deceased assets, to obtain money from their bank accounts, to sell shares if they have any, and to sell property. The other situation was where the deceased has made a will. When they've made a will, certain forms have to be completed. It's a form known as an IHT form PA1P in all cases, which sets out details of the estate, also other forms with acts. The inheritance tax threshold is currently £325,000. That doubles if someone is married because they can rely on their wife's exemption, and an application for a grant of probate. If inheritance tax is due on the estate, the inheritance tax has to be paid before the probate registry will issue the grant. if
So it seems
inheritance tax.
sorry,
Yeah, sorry.
it seems to be there's quite a bit of information there, and there's a
There
lot of
is,
steps
yes.
to be taken. It seems to be quite a complex matter, and often people do need a solicitor involved in this process.
Well, you're quite right, they do, and I would always give people that advice to see a solicitor, particularly if the estate is in any way complicated. The very simplest estates may not need a grant at all. Perhaps if somebody's got a couple of £1,000 in a savings account, you can often access that estate without needing a grant of probate, just relying on a death certificate. But for anything more complex, and certainly a property is involved, such as a family home, it's always best to seek legal advice. But the second part of your question, that's probate. Second part of your question, what is contentious probate? Contentious probate is where the will is disputed, or it's where somebody doesn't make a will, somebody claims to be a dependent to the person who's died. So, for example, with a will, it may be obvious looking at a will that the will isn't by a beneficiary, that the will isn't what was expected. For example, a wife would be expected to inherit a share of her late husband's estate. If the wife receives nothing under the will, she can challenge it and go to court and say this is unfair. Might be a
Can I just
perfectly
just
yeah,
stop you
sorry.
there, Andrew? Because I often have clients. It's a very common question, and ordinary lay people have this question, and that is, if there's a will, that's it, isn't it? There's a will, and the wishes of the will should be carried out to the letter, and those are the wishes of the deceased, and whatever the will may say, as long as it's a valid, properly executed will, and the deceased had capacity, i.e., mental faculties at the time, and there's a will, and if they want to leave it to their dog's home or to any distant relative, that's their wishes. How on earth can you challenge that if it's a good, valid will?
Well, under English law, you can, because English law depends on a principle known as equity, which means fairness. It's really there, if you like, to referee situations and to establish that justice is done. So a person can be a perfectly sound mind, perfectly healthy. They can make a will leaving their estate to a charity, maybe for the best of reasons. But if they're a married person and they've got a wife, and particularly if they've got a family, the family can say, well, wait a minute, my late husband or late wife liked cats and dogs and wanted to provide for them in the will. This is unfair. We've been left penniless. They would then make an application to the court under a piece of legislation called the Inheritance Provision for Family Independence Act 1975, which is really a law which makes sure that relatives are not disinherited under a will. So that's how you challenge a will like that. You'd say, even if it was a perfectly valid will, it didn't provide for me, that isn't allowed by law, I challenge it. So you could challenge a will in that way. There are other ways too. A person of sound mind could make a will, but it might not be properly witnessed. You need two witnesses to a will who have to be there at the same time. If that doesn't happen, the will isn't properly attested, as it's called, it isn't a valid will. The other scenarios are where you have a will which is an irregular will, by which I mean the person perhaps doesn't have capacity, they're not acting from their own free will. They might have a relative or some other person with bad intent forcing them to make a will which benefits them. Again, that can be to the disadvantage of children, a wife, whoever. That will can be challenged in court because it's been obtained by what's known as coercion, by force. Or, of course, you can have a situation where somebody isn't of sound mind making a will. They don't have the mental capacity to make a will. They might have, as so people sadly sometimes do, increasingly, dementia, or they might have some form of other mental problem, might be blind and perhaps can't read what they're signing. Specifically, in the Sikh and other Asian communities, people may well sign a will in English, and which they're not able to read because they don't read the English language. So they don't know what they're signing. A will should always be written in the language that the person who makes the will, known as the testator, can understand. So all those things can lead to a situation where will is challenged.
And challenging a will, it doesn't seem to be a straightforward process. Is it an expensive process? How would a client go about it? How do you act for your clients? Does it take a very long time? I mean, that's the next question clients often have is, will it take a
Well,
long time? Will it be a very expensive
the
process? And
answer to that,
does it have that reputation?
the answer to that, it varies, and every case is different. But the most important thing to do when somebody dies, and you believe they have a will that you're not provided for, is to act quickly. Because what you need to do is register a type of restriction known as a caveat at the probate registry. Now, what a caveat is it puts a stop on a grant of probate being issued. Because if a grant of probate is issued, the person who's obtained the grant of probate can then sell assets, access bank accounts, disperse the estate, the money's gone. So the most important stage is to act quickly. That I'd say to anyone, whether solicitor or not, they need to act quickly and register a caveat. Otherwise, things don't stand still and the estate could be lost. That's
And
the most important thing.
can people do that themselves? Register a caveat, or do they need a solicitor?
In theory, you can, but the problem is there's an old adage that a person who acts for themselves has a fool for a client. Often when people don't act for themselves and don't know what they're doing, it goes wrong. So the safest route is always to go through a solicitor who has indemnity insurance in place if they make a mistake. So that is always the most important route to follow. Enter a caveat, and that puts the situation on hold, and then you would write to the individual who's seeking probate. You would challenge the will to what's known as a protocol letter, also known as a letter before action, setting out why you challenge the will. It may be, once you challenge the will and set the reasons out, that the matter can be resolved without going to court. Because what usually happens in these cases, at one stage or another, is there's what's known as a mediation, which is the parties sit round the table with a trained mediator, and usually the dispute is settled before it gets to court. If that doesn't happen before proceedings are issued, ultimately a claim would need to be issued and it would proceed towards court. But again, I would emphasise that most of these disputes do settle before court. It's only a very tiny minority, I would say under 5%. It's a very small percentage that actually end up in court. So
That's
the
very
chances are,
reassuring because
even in
clients
the
don't wish to go to court. And if you can settle out of court, avoid litigation, that's all the better.
well, that often happens, and it's strange. These cases don't always have a detrimental effect on the family in the long term. I've seen cases where people have been, daggers drawn, caused huge disputes in the family, but afterwards there's been a negotiation, a mediation, and they've shaken hands afterwards and often gone on to build relationships after the disputes. These sort of disputes can be reconciliatory sometimes. It doesn't always have to lead to a breach in the family. Good can come out of it in the end in building family relationships once these issues have been resolved and the problems have been aired.
Thank you very much. Thank you, Andrew, for that. We've also been joined by Jonathan Edwards. Jonathan is a senior barrister, counsel, who's used to acting for clients in a personal injury setting, although he has a wide-ranging practice. Jonathan, welcome to the SIKH Channel Legal Show. Would you like to introduce yourself briefly to the viewers and your area of practice?
Well, you're right. I do practice in the area of personal injury cases, and I have done other kinds of civil litigation, but I've done many things in the law over the last several decades. And one thing I've never done is appear on the SIKH Channel before. So thank you for the invitation for that.
Welcome. We're very pleased that you're joining us this evening. And over the decades, you must have seen a lot of change. We've had the CPR, which is a new set of rules and a way of doing things. But what other changes have you seen, specifically in the area of injury claims, where people have accidents or injuries at work?
Well, one of the big changes was the civil procedure rules, because they make you do something which you might think was obvious, and that is prepare your claim before you go to court. It helps to know, have you got the evidence? Are you going to be able to satisfy the legal requirements? Don't make it up as you go along. Don't start litigation unless you look at it in full and come up with the feeling that you're likely to win. And that the civil procedure rules are quite strict. The judges are quite strict with them. But I have found that if they're applied, then you get to a better result more quickly. Or at least you did until the government cut the budgets, and court hearings are now often delayed, which is a pity.
And claiming for injuries has changed quite a lot over the last 5 years or so. Can you tell us briefly, for the general public, for our viewers, about the changes in the personal injury world?
Well, one of them affects the general public, and the other really only affects the lawyers. The insurers were fed up with paying out on small claims where people had been in small accidents and very commonly had a whiplash injury which lasted, let's say, 6 weeks. And the insurers got very fed up with not only paying out damages to the client, but also paying out large legal costs to the lawyers who'd run the cases. And they lobbied the government, and the government completely changed the rules. So if you were expecting to be involved in a small road traffic accident and then to come away with £2,000 or £3,000, you probably can't now. You're probably directed, go online, go to a portal, log in, and see if you can come away with £500. It made a lot of difference to a large number of these smaller cases. The other claim, the other thing that's changed is the government are trying to control what insurers have to pay out in legal costs. That is to say, if the claimant wins a claim, they will get their legal costs. And the government have found ways to cut down the amount that the insurance companies have to pay. This
it seems to be geared towards helping the insurers more than the injured party.
Well, that's politics, isn't it? Insurance companies are able to lobby governments of both colours, of any colour, and they did do that, and they succeeded. And these changes were made. It's right to say that some senior judges, one in particular, was very keen on changing the system in this way. And he went at it seriously over a long period of time to do this. Lord Justice Jackson, very nice man, very clever man, but he was absolutely set on making the justice system simpler in this area.
Has he gone too far? Has he now weighed too far in the favour of the insurance companies, and the small person, injured person who's working in a factory, had an accident at work, has greater obstacles to getting compensation? Andrew, what do you think about that?
Yes, I think it has, Davinder. I think the scene has totally altered, and sadly, not to the benefit of consumers of personal injury claims. And I think Jonathan makes a good point. that I can remember, although I don't profess to be a personal injury specialist, but back in the days when I handled personal injury, a whiplash claim in a road traffic accident would typically generate damages of £1,500 to £2,000, and now, as Jonathan says, we're down to £500 for that type of claim. So the world has changed, and it has been politically driven to the benefit of the insurance companies, sadly, and not to the benefit of the person who suffered a personal injury. And of course, the other offensive thing about personal injuries is the comparatively small amount of damages you get compared with other areas of law, such as libel, for instance, defamation claims, where you can get hundreds of thousands of pounds, but sometimes you're awarded less for quite a serious, life-changing injury. So those sort of things as well are unjust, and also the number of solicitors who specialise in personal injury have been forced out of the marketplace because the market has contracted. And again, that isn't to the benefit of claimants either. So it's a different landscape, and sadly not the landscape it was a few years ago.
So, Jonathan, if somebody suffers an accident, say an accident at work, what should they do? What are their immediate steps?
See what they've got to say at work, get hold of an accident book, basic records like that, and think about what's the nature of your injury. And you're going to probably see your GP, probably, if you can get in. And another basic document would be a copy of the GP record, the records of your own GP. So you go in there with a cold one day, but then you've got this injury to your arm or your leg or whatever it is the next day. And it's a very quick and relatively cheap way of working out what is happening to your injury and where it's likely to go. There'll be notes on it. Your doctor will be talking to other doctors, and you'll have a pretty good idea of what the injury is likely to end up at. And I say go to the medical records because I find them pretty complete and pretty helpful, and there isn't much more you need to know. But at some later stage, you're going to have to get a more comprehensive, directed, focused report from an expert. And the trick will be, how is that paid for? Do you have to pay £1,000, £1,500 for it, or is there some other way by which it can be paid? And you want to talk to your solicitor about that.
And Andrew, if somebody wants to make a claim after an accident at work, often they're fearful for their job. And the first question that the clients ask is, will I lose my job if I make a claim for an accident at work? What would you say to them, Andrew?
Well, Jonathan is probably more specialist in that than I am. But of course, to dismiss somebody for making a claim could result in a claim for unfair dismissal, which would be an employment claim. That shouldn't really happen. Neither, in truth, should an employer take it personally, because an employer is going to have a public liability insurance and other forms of insurance. So it's simply a matter of the employer making a claim on their insurance policy. It's then taken out of the employer's hands. It's handled by solicitors instructed by the employer's insurers and by the insurers. So employers shouldn't take it personally, but certainly if any employer did and they dismissed an employee, that would give rise to an employment claim for unfair dismissal.
Andrew's quite right about that. In fact, one of the reasons I was a little bit late joining was I've just come back from court where on behalf of a tenant who had made a complaint about the condition of the house to the landlord, and it had gone sour, and the landlord gave the tenant notice to quit because he was fed up with the trouble she was causing. So, I mean, that could get a little bit difficult in court. But as Andrew says, I don't think it's likely to happen in an employment context, because it'll go to the insurers and it'll happen in a slow way a year or two later, and not get in the way of. I mean, I had a case where the employer was very good about it. Oh, you're injured. Sorry to hear that. You can work from home for a bit. You're welcome to come back when you're able. He was able to come back to work and did go back to work, and the claim proceeded anyway. So it shouldn't cause that particular problem.
Also, there's other legislation. So I was just going to add, also there's legislation in place. The Equality Act springs to mind, when employer has to make reasonable adjustments for an employee who's disabled, who's unwell. So it's up to an employer by law to accommodate an injured employee, not vice versa. And a tribunal certainly would be horrified if an employer's response to a claim was to sack a person who claimed, albeit I accept that sometimes, horrendously, that does happen, but really it shouldn't, and an employer who did that would feel the weight of the law against them.
Thank you very much, Andrew. Finally, final question for both of you. Perhaps we can start with Jonathan. Clients, I think, are generally aware of the 3-year rule, 3 years to make a claim. Does that mean that a client can and should wait as long as they want to make a claim and take it up to the 3-year limit?
No, there's no advantage in doing that. Now, obviously, if you're injured and you've got 3 years, well, let's see what happens to the injury. Do I get better or do I not get better? You might not know in the first year. You might not know in the second year. You might not know in the third year, but you know you're injured. And so what you should do, claim as soon as you can, get the medical records, ask your solicitor, can I get a more formal medical report? And it will say, yes, definitely an injury. We don't know yet. It needs a review in, let's say, a year's time, or we better go to a specialist. And you can have 2 bites at the cherry, as it were. You explain to the court, we've made the claim knowing that we didn't know the final position, but so can we also have an updated report when we do know the final position? And in that way, it can go way beyond 3 years.
Thank you very much, Jonathan. Andrew, is there a limitation period for contentious probate? Can people wait?
There is,
6 years?
Indeed, Davinder, and thank you for highlighting that. The limitation period for contentious probate is double that of personal injury. It's 6 years. Apart from when a dependency claim is brought, which I mentioned earlier, your wife or child, etc., who's been disinherited, that should be brought ideally within 6 months of the grant of probate being issued, although there are exceptions where that period can be extended. That's not a hard and fast rule, but generally that should be adhered to. But the main thing, as I said, with probate is, regardless of the limitation period, it's a mistake practically to sit on your hands, because if you don't act quickly, you're running the risk that the estate, a grant of probate is issued, and the estate is administered and all the money's gone. So that would be the disadvantage of waiting for 6 years. But yes, you do have a long stop date of 6 years in probate.
Thank you very much. Thank you very much, Jonathan Edwards, Senior Counsel, Specialist in Personal Injury Work, for joining us, and eminent solicitor Andrew Lucas, Specialist in Contentious Probate. Thank you very much for joining us and offering your views and your advice without any particular caveat or without any commitment to the viewers, and as a general advice clinic. Thank you very much for joining us. We hope you'll join us again in the future. We may take calls from our viewers and ask them. They may have some questions for you, and perhaps next time we can have a call-in show where you can speak to the viewers and try and help them further. Thank you very much.
Yes. Well, thank you for having us on the SIKH channel, Davinder, and thank you to your viewers for watching, and I wish them good evening.
Thank you.
Well, Davinder, is it a question of like, click and subscribe? Do you do that on your channel to help the channel? Because we can all do that.
Yes, we do. We have a very good YouTube page and an app and social media, as well as being on Sky. And I'll send you all those details. You can watch this program. Thank you very much. Thank you, gentlemen.